Delhi Judicial Service Association versus State of Gujarat. Citation AIR 1991 SC 2176. Name of the judges in case K.N. Singh and Kuldip Singh, Kasliwal. The facts of the case were: N.L. Patel, who was appointed as the Chief Judicial Magistrate at Nadiad in 1988, he found that there was no cooperation on the part of police in delivering summon for producing the offender for trial. He then wrote a letter to the DSP and also forwarded the copy to the DGP, but no action was taken by both the DSP and DGP. By this letter, the police inspector of that area, who was S.R. Sharma, he was annoyed by the behavior of C.J.M and he withdrawn the constables from the C.J.M Court. N.L. Patel, who was the C.J.M, then filed a complaint against the police inspector of Nadiad, who was S.R. Sharma, and other police officers. He filed a complaint related to the delaying the process of court. Later on, C.J.M also directed the police to file criminal case against 14 other pupils who are delaying the process. But the police officer did not take the matter seriously, and the police inspector was frustrated by the behavior of the C.J.M and he filed a complaint against the C.J.M to the Registrar of High Court through District Superindent of Police. On one day, the police inspector invited the C.J.M to the police station and asked him to check all the documents for himself. And the C.J.M also accepted the invitation of the police officer and visited to the police station. But what happened in the police station that really shocks the nation. C.J.M was forced to drink liquor in the police station. He was tied up by the constables. He was then even photographed in the drunken state. The police inspector, the S.R. Sharma, then made an argument in his favor that the C.J.M was drunken. He was in drunken state when he even got there in the police station. The issues of the case were: did the arrest made by the police inspector amount to contempt of court? And the second was: can the Supreme Court intervene in the decision of the subsidiary court? Because under Article 129, there the Supreme Court has a power to punish the contempt for itself. Now the question was whether the Supreme Court can take the contempt of subordinate court too. Now the issues were answered. First was: the arrest made by the police inspector was not of some ordinary person. The person was the C.J.M and he was furnishing his duty in the interest of state. And under Article 136 of the Indian Constitution, it has been stated that the arrest of a person who is working for the judiciary would amount to contempt of court and would be liable for punishment. And the second thing is that Article 136 of Indian Constitution, under this article, the court has power, Supreme Court has innumerable power, that even he can intervene in the proceeding of any high court where it found that there is a miscarriage of justice. The judgment of the case was that Supreme Court took this matter very seriously. Many lawyers also had filed petition regarding the removal of police officers to the Supreme Court, and the Supreme Court had taken the cognizance of this case and has ordered the removal of the police inspector and other 5 police officials immediately from their term. And the police inspector was awarded with a simple imprisonment of 6 months and a fine of 2,000 rupees. The other officials were made to pay 1,500 and imprisonment of 15 days and 3 months respectively. Guidelines which were issued in this case were: first was that if a judicial officer is to be arrested, then the intimation has to be given to the district judge or the high court. And second was, if there is a need for immediate arrest, then the arrest need to be formal. Third was, fact of such arrest should be effectively communicated to session judge or to the district judge. Fourth, the arrested judicial officer shall never be taken to the police station without the prior order from the district or session judge. Fifth was, all the communication should be provided to the judicial officer for his communication with his family members, lawyers, and with district or session judge. And sixth point was, neither Panchnama nor the medical test should be done except in the presence of legal advisor. And seventh one, no handcuffing of the judicial officer shall be done except in cases where there is an extreme threat to the prisons around him by that officer. Only then force can be used against him and can be handcuffed. The PDF of this case law, the link for that PDF is in description. You can download from the link.